Can I start?
Yes.
Okay. I'm just going to start quickly share my screen and then we take it from there. Right. So good morning, everyone. Thank you so much for joining us for this session. Just by way of introduction, I'm Kanika. I am currently pursuing my PhD at the Faculty of Law at NUS. Here, my doctoral research focuses on community-based water governance in India. So it's a social legal project. Where I'm looking at how do communities manage water in India. But before coming here, I was teaching at Jindal Global Law School in India. I was teaching climate change and environmental law. And that's where actually I sort of conceived much of what I'm talking about today in terms of the research. So what this lecture sort of focuses, or this talk rather focuses on, is India's judicial jurisprudence on the rights of nature. And I'm going to be analyzing its transformative potential, how transformative is that jurisprudence. So just generally, for those of you who might not know this, India has a system of public interest litigation wherein any individual citizen can move the highest courts of the country in a matter that is of public interest. And much of India's environmental jurisprudence has actually emerged from the courts, where the judiciary has been really proactive and pro-environment and has developed a lot of environmental jurisprudence in India. So even with regards to rights of nature, the Indian judiciary has taken keen interest in it. And starting from 2014 up until recently, between 2023, there were around seven decisions, I guess, that I am aware of, which came on this issue. And there have been two cases that have come from the Supreme Court, and the remaining are from different high courts of the country, that is different courts in the provinces. So I'll be walking through those. But before I go into, the more analytical part of the conversation, I just want to take some time to actually talk about what is transformative governance, and how does the rights of nature discourse fit into this idea. Because while transformative governance is something which has been talked about, the introduction of rights of nature is a fairly less talked about or less discussed idea within transformative governance. So I just want to take some time to shed a bit of light on that, and then use that sort of framework to analyze the judicial decisions as we go forward. So bear with me. There's going to be a bit of theory coming your way, but I hope it's interesting. Right. So the idea of transformative governance, right? It's rooted in the idea of transformative change. So what is transformative change? Transformative change essentially would be change that is change in our social, our economic, and our political goals, such that we're able to address the environmental crisis that we face today, right? Why these goals? Why bring change? Why bring systemic change within these goals or within these sectors? The reason is that these are considered to be the indirect drivers of the multifaceted environmental crisis that we face today, right? So reorganizing our political values, our social values, our economic values, or technological interventions, right? Reorganizing those, bringing in new perspectives, new paradigms of thinking, and new values into these goals, and then sort of trying to address this environmental crisis that we face today. And what is one of the ways to bring about this change, right? As of course, one of the ways is law. So therefore, transformative change is enabled through law, through transformative governance. Now, of course, governance would then not just include law, but also the process of making law and the institutions that are then involved in this lawmaking process, right? So to bring about transformative change, we need to mainstream the newer ideas, the newer values, or the newer ways of thinking into our lawmaking processes, into the institutions that are involved in lawmaking. So in a common law country like India, right, law is not just understood as something that's coming from the legislature. We also have law, like I suggested in the beginning, we also have law that comes from the courts. Judicial decisions are precedents and they're binding, and they are a source of law as well. Similarly, policy that comes from the government also forms a part of law, in the sense that it does guide a significant amount of environmental regulation in the country. So that's sort of the broad understanding of law that I'm going with here. So the idea of transformative governance is then that through these institutions and through this normative framework that governs our day-to-day actions, we bring about a realignment of our social, our economic, our political, and even our moral goals and our values, such that we're able to address this larger environmental crisis that the world is facing today. Now, where does the rights of nature come into all of this, right? Now, the literature identifies 4 approaches to transformative governance, of which it is inclusive governance where the rights of nature debate situates itself. In theory, what is inclusive governance? As the name suggests, it's literally including different stakeholders into the process of decision making. So a wide range of actors into the process of decision making. And that basically is one of the first things, like, who are you including? So you're including a wide number of people. Mostly it will be people or interests who have so far been underrepresented in the process of decision making. So you empower these people in order to, so you empower the underrepresented sort of voices in order to sort of participate in the process of lawmaking, of decision making. And how do you do that? So you do that by, one of the ways is, of course, giving them rights, which are based in the values that help in representing their interests, right? In representing interests, underrepresented interests. So that is one of the ways that inclusive governance operates. And what are the ends? Why do we need inclusive governance? Of course, to ensure that there are just outcomes for all individuals or everyone involved in the process. This is exactly where the whole conversation on rights of nature actually comes in. So when I look at inclusive governance in the context of the non-human environment, right, meaning that, and here I'm not sort of differentiating between sentient living beings and non-sentient living beings. So I'm talking about all non-human environment, which includes plants, rivers, soil, animals, water, and all of that, the entire basically ecosystem. So when the interests of the non-human environment are represented in decision-making processes by, say, granting them rights, and these rights need to be based in an eco-centric worldview, right? Why? Because, and this is, I'll take some time here to differentiate between eco-centric and anthropocentric worldviews. So say, for example, we're talking about the interests of non-human environment, right? An eco-centric worldview is basically one which ascribes intrinsic value to the non-human nature, right? So we need to value trees because there's some intrinsic value in trees. While an instrumental or an anthropocentric approach would say that, okay, we need to preserve the environment because it's instrumental to human beings. So for example, our whole idea of sustainable development kind of hinges on instrumental value of nature, protect nature such that our future generations are also able to enjoy it in the ways that we have. So, but then at the end of the day, when you look at an anthropocentric understanding, or when you grant rights to nature on the basis of anthropocentric ideas, what interest are you protecting? You're not protecting the interest of the non-human environment, At the end of the day, you're protecting the interest of humans. That is the reason why you're prescribing rights for the non-human environment, right? So in the idea of inclusive governance, then what we have to be very careful about is that, sure, we give rights to the non-human environment, but these rights have to be grounded in an eco-centric worldview. And that's the worldview, or that's the perspective which is underrepresented in decision-making. So that sort of needs to come in. And that's almost corollary and like prerequisite to protect the interests of the non-human environment. Otherwise, we're not protecting the interests of the non-human environment. And again, what would be the ends in this case? The ends would be ecological justice, as opposed to what I say, as I write, environmental justice. Right. So, of course, environmental justice talks about fairer redistribution of environmental harms across humankind, while ecological justice actually talks about justice for the non-human environment. And therefore, the ends that the rights of nature should meet is that of ecological justice. And only when we have all these components together can we argue that we are facilitating, transformative governance, or that this governance is transformative. So then I sort of use these two yardsticks to analyze the jurisprudence on rights of nature. The first one being that I look at whose interest is being protected in the decision. So, okay, rights have been granted to rivers, but is it the interest of the rivers that's actually being protected or not? Prima facie, if rights have been granted, the idea is, yes, it's the interest of the entity who's been granted rights that we are protecting. But is that actually the case? And how do you determine that? You see what is the underlying motivation for it. What is the worldview that's guiding this grant of rights? In the case of the rights of non-human environment, this worldview, I argue, should be ecocentrism. I must point out here, there are other paradigms. There are paradigms like biocentrism, which only relate to non-sentient living beings. But like I said, my concern here when it comes to rights of nature, and given how the jurisprudence is also developed, it's not been limited to only non-sentient living beings. It's also extended to the non-human environment, more like for example, non-living beings as well, right? So rivers, rocks, so on and so forth. In fact, there are arguments that these beings are also living, but I'm going to step aside that conversation for now. But just to give you an idea that's where I am coming from, and that's the view that I am ascribing to. And then we use all of this to understand how has the jurisprudence developed. So the conversation on the rights of nature in India started as soon as 2014. And this was one of the first cases. It was a path-breaking case that came in 2014, wherein animals were given right to life in India, right? So under the Indian Constitution, Article 21 of the Constitution protects right to life for human beings. And this is a fundamental right there in India. It's a basic right in India, which can actually be redressed right at the level of the Supreme Court or even the High Court. So if any individual feels that their fundamental right has been violated, there's a direct writ petition that can be filed at the highest court in the country. So in this case, it was again a public interest litigation against a particular sport in India, which was the sport of bull taming. And the argument at the time was that the way the sport is being conducted is causing unnecessary pain and suffering to bulls. So amongst many other eco-centric sort of statements that were made by the state, this was the part where the state, where the court, attempted to extend the ambit of right to life under Article 21 to then include animal rights. And if you look at this excerpt, right, so the court first starts out with an instrumental understanding of right to life, wherein it says that life has been expanded. This part here, line 4, says that Article 21 of the Constitution, while safeguarding the right of humans, protects life, and life has been given an expanded definition to include any disturbance from the basic environment, right? So my right to life also includes a right to enjoy a pollution-free environment. Now they say that this basic environment also includes animal life, which is necessary for human life. So here the court is sort of going, it's giving a more instrumental understanding to right to life for animals, meaning that animal life is valuable in so far as it helps individuals enjoy a right to life, their life under Article 21, right? So more of an instrumental value, because of course plants, animals, all of these form a part of our basic environment, and therefore we need to protect them, we need to protect their life so that humans can also enjoy their own life, full enjoyment, complete enjoyment of right to life under Article 21. But if you look at the last line of the decision, right, it goes on to say that so far as animal life is concerned, it means something more than mere survival or existence or instrumental value for human beings, but to lead a life with some intrinsic worth, honor, and dignity, right? So here, then again, you have more of an eco-centric, leaning of the court, where you see that the court is saying that, okay, animal life actually has some intrinsic value and some intrinsic worth. And it is literally just this one paragraph where the court stopped this discussion on rights. This is the only discussion on rights in that entire judgment. So after this decision came, of course, it has been celebrated for actually not just giving rights to animals, but also almost giving fundamental rights to animals. But as one can see that this is a bit, it's a bit ambiguous, at least from where I stand. Well, to what is the ambit of the right? Is it actually eco-centric? Does it actually protect animal life, or does it only protect animal life insofar as it's instrumental to human life? So those were a few questions that came up after this decision was pronounced. But nevertheless, I think at the time, given that this was one of the first decisions in the series of decisions that followed later, this decision was celebrated, and in fact became a basis for several eco-centric decisions that came on later. So this was in 2014. It was a decision by the Supreme Court of India. Then we had in 2017, we had a case in the Uttarakhand High Court. So Uttarakhand is a province in the north of India. We had a decision from the Uttarakhand High Court where the High Court gave juristic personhood to two rivers in India, that is rivers Ganga and Yamuna. These are revered rivers. So juristic personhood was granted to these rivers. And again, it was hailed like in more sort of popular media reports, it was hailed as a groundbreaking decision again, because this is arguably like a non-living entity which was given rights. However, when you again like a closer look at the decision, what was the motivation behind giving rights and whose interests are being protected here? So on juristic personhood, the court goes on, starts by saying that this recognition is to subserve the needs of faith and society, right? So again, the interest that is being protected, or the motivation for this recognition was, of course, to protect faith and society. And then I put some more excerpts that go in the same sort of lean in the same direction. So for example, the court said that to protect the recognition and the faith of society, rivers Ganga and Yamuna are required to be declared as legal persons. And then they went on to also note that both these rivers are central to the existence of half of the Indian population and their health and well-being. And the rivers provide physical and spiritual sustenance to all of us from time immemorial, right? So largely it seems that the court was being driven by the value that these rivers hold in the Indian society and their instrumental value for human beings and how they enrich human lives. And therefore, the court went on to grant juristic personhood to both these rivers. So in this case, if we go back to whose interest is being protected and whether it's ecocentric or not, this case on the face of it to me seems completely anthropocentric in that sense. Sure, rights have been granted, juristic personhood, and then rights were granted to the rivers. But what was the motivation? The motivation does not seem ecocentric and also does not seem to be protecting the interest of the rivers, but more so it seems to be catering to the interests of humankind. But shortly thereafter, and this is where there was a slight shift in the court's jurisprudence, we had from the same High Court another decision coming in on the juristic personhood of non-sentient nature, right? So on rivers, and sort of other aspects of the ecosystem, particularly more so on rivers and glaciers and so on and so forth. So we had jurisprudence on this from the same High Court, and here you see a larger leaning towards recognizing the intrinsic rights of the non-human environment, and also recognizing their inherent value. So again, I have some excerpts here from the decisions wherein you see that the court has said that there is an intrinsic right of the rivers not to be polluted, and pollution is then equivalent to harming or hurting or causing injury to a person. Polluting a river is equivalent to causing injury to a person. In fact, the court also went on to say that rivers are not just water bodies, these are scientifically and biologically living entities, right? Therefore, you need to sort of grant juristic personhood to them. They regenerate their own vital ecosystem, and the fact that, of course, we must recognize and bestow constitutional rights, not just legal rights, but constitutional rights on the entire non-human environment. So here you do see that the court is engaging in a more sort of ecocentric understanding of the non-human environment, and why should rights be actually granted to the environment. But then in the same paragraph, we see some anthropocentric leanings. So you see, statements like, we need to pass on the earth in the pristine glory in which it was handed over to us. So again, the whole idea of sustainable development, that, protect resources such that the future generation is also able to enjoy it and use it like we have. So there's that anthropocentric leaning where protection is again tied in to an instrumental value. And of course, the second excerpt here, that juristic personhood needs to be granted to subserve the needs of faith and society, and for the bigger thrust of socio-political human development, essentially, right? So there are these, again, anthropocentric undertones in the decision, but I would say that this one was a significant, move up from the last one, wherein that was largely anthropocentric, but this one, I would say, had significant amount of ecocentric motivations as well. What is also interesting is that both these decisions quote the same jurisprudence, and it draws on the previous decision, and it was also, in fact, authored by the same judge, but there is a progressive movement in the understanding of what is the purpose of granting rights to nature, and in the more ecocentric leanings of the court. And then I think this I would call was a major jump. So there were two decisions, one in 2018 and one in 2019. Again, one came from the Uttarakhand High Court and one came from the High Court of Punjab and Haryana. These, again, like two provinces in north of India. So we had two complementary decisions, almost similar to each other in terms of the jurisprudence. And this, I would say, is a major jump. And this is where I think eco-centric jurisprudence has, at least until now, seen a peak, wherein the court went on to grant juristic personhood and rights on animals, the high courts, wherein they said that animals have a right to self-determination, rivers have an inherent right to flow, and animals also have a right to life and bodily integrity and honor and dignity, and that they cannot be merely treated as property. So I think this, the court also sort of engaged in a discussion about how in law it's either person or property. That is a dichotomy that we deal with. So the court said that animals cannot be treated like property, they're actually persons, and therefore they have intrinsic rights to life, to bodily integrity, honor, dignity, and they also require self-determination. And rivers, of course, the court said, has an inherent right to flow. In the same decision, then the court goes on to say that every species has an inherent right to live and is required to be protected by law. And rights and privacy of animals, in fact, is to be protected from unlawful attacks. And I must highlight here that this first paragraph that you see here was actually what seems to be the court's interpretation of the 2014 decision that we discussed in the beginning. Wherein I pointed out that seems to me like it's a bit ambiguous in terms of whether it's granting rights or whether it's ecocentric or not. But here the court seems to have given a very clear idea and understanding that animals do have an intrinsic right to life, and that this right should, in fact, this extends to privacy also, and it needs to be protected from unlawful acts. And then, while granting juristic personhood, so far we've seen that the court has said that juristic personhood has to be granted to subserve the needs of faith and society. But if you see here, the court is saying that we need to grant juristic personhood to protect and promote greater welfare of animals, including avian and aquatic. Animals are required to be conferred with the status of legal entity or a legal person. So again, the whole motivation for granting juristic personhood, right, that shifted, and that majorly shifted from more anthropocentric leanings, wherein, okay, we need to grant juristic personhood to subserve the needs of faith, of humans, of society. We now see a more ecocentric leaning that you need to grant juristic personhood to protect the interests of the animals themselves because they have some intrinsic value. Right. So this is where these two high court decisions that came one after the other, we see a major jump in the ecocentric jurisprudence of the court. Now, this was a more recent decision that came from the Madurai High Court in 2022. This decision actually did not engage in a very, it did not engage with the jurisprudence so much. In fact, that conversation on ecocentrism and anthropocentrism was actually absent, but it did go on to grant juristic personhood to the entire mother nature, quote unquote. And I tried to figure out what was the motivation of the court, but again, the discussion on that is quite thin. But what it seems to me is that the court did have some anthropocentric leanings, but at the same time, there were some ecocentric rationales that were given, and those ecocentric rationales were actually excerpts from previous judgments and just put there and then said that we are granting juristic personhood. So actually the court's engagement here with this issue was not that at length, because actually this was not the issue in question. But nevertheless, the court went on to say, if you see the first part, right, the natural environment is a part of basic human rights of right to life. And whatever sort of environmental damage we are facing is strongly impacting human life. That was one of the rationales that the court seems to have put forward, right, which is similar to what we saw in the initial part of the 2014 decision, wherein animal life should be protected insofar as it's instrumental to human life, right? So here the court seems to say that, okay, we need to protect the natural environment because its degradation is impacting human life. So again, it seems to be protecting the interests of human beings. And then, of course, the court does go on to quote some eco-centric sort of paragraphs from one of the initial decisions, the one in 2017, and it says that rivers are ecologically living beings. They are biologically they're biologically living beings, and they have an intrinsic right to flow, so on and so forth. So again, I would, and then it goes on to grant juristic personhood and related rights. So this again, sort of the 2022 decision of the High Court was a bit ambiguous, I would say, in terms of its motivation. Sure, it was very clear that it's granting rights, but the motivation, in terms of the motivation that I've been discussing so far, and in the context of that framework that I sort of presented up front, whose interest is being protected, and is it ecocentric or not? I think it was a bit ambiguous there. And then this is the most recent decision from the Supreme Court from May 2023, where actually the court has overturned its 2014 decision, saying that the way the sport is conducted is now no more causing unlawful harm to animals. So we are allowing the sport, but that portion of the decision aside, my interest here was to look at the court's jurisprudence on juristic personhood and rights. So what was actually interesting was that the court says that both the parties agree that animals do have rights, but what those rights are and what the content is going to be is not the prerogative of the judiciary, but rather the appropriate lawmaking body, which is the legislature, right? So the court kind of doesn't say that, no, that animals don't have any rights. In fact, it does recognize that, yes, animals do have rights, and that's what both the parties have also argued there. But what those rights are, that is not it's not under the prerogative of the judiciary to determine this or to interpret it. It is actually the job of the legislature. And so on that, the court stops the conversation there. On fundamental rights, whether there are rights under Article 21, the court says that on the question of fundamental rights, we don't have any precedent. And here it's interpreting its own case, the 2014 judgment, as saying that it does not lay down fundamental rights for animals. So under Article 21, animals don't have rights. Sure, animals have some rights, but what those rights are has to be determined by the legislature and not the judiciary. So that was the approach of the court. Now, what I've tried to do here is that I've tried to map out this approach in this sort of diagram, wherein the top line that you see here is that the decision was overwhelmingly eco-centric, and it furthers ecological justice, and it's transformative. The other here is that it was overwhelmingly anthropocentric, and then in the middle we have that it was rather ambiguous. Now, the reason why no decision was fully ecocentric or fully anthropocentric is because it actually wasn't. You find a bit of motivation, both kind of arguments put forward, which is why I've made this standard of overwhelmingly ecocentric and overwhelmingly anthropocentric. So starting off with the 2014 decision, right, where we saw the court for the first time tried to include animal life within Article 21. Given the fact that it was one of the first such cases, and the remaining part of the judgment, which at length discusses ecocentrism, and this judgment actually, different parts of the judgment actually went on to become grounds for the further cases. My understanding was that, sure, that the decision was a bit ambiguous, but it was sidelining more with eco-centrism. In fact, it declared a provincial act as anthropocentric and said that it's repugnant because the union legislation on prevention of cruelty to animals was an eco-centric legislation. So the court was aligning more towards ecocentrism in 2014 when that decision came. Then we had the 2017 decision, which had on granting rights to rivers Ganga and Yamuna, which I felt was overwhelmingly anthropocentric. Sure, rights were granted, but motivations and the interests that were being protected were all human-centric. And then the same jump in 2017 where we saw non-sentient environment, right? The decision on recognizing intrinsic value of rivers, calling them, recognizing them as scientifically, biologically living beings, that I felt had, sure, there was ambiguity in the sense that it says that yes, juristic personhood is being granted to fulfill the needs of faith and society, but it was leaning towards eco-centric. And then, of course, the major transition that we see in the two decisions that came in 2018 and 19 on animal rights and granting juristic personhood to animals, those I would say were overwhelmingly eco-centric. They had the right, they had taken a right worldview, and they had also tried to protect the interest of animals for their intrinsic value. So they were eco-centric, and they were trying to actually further eco-justice. And then we had 2022, the decision from the Madurai High Court, which seems to me was ambiguous, but again, leaning towards anthropocentric, given of course, the decision was thin. So it's not easy to determine what the motivation was, but from what I have, what I read in the judgment, that is where I would place that decision. And then the 2023 decision, the most recent Supreme Court decision, I think the court's decision was actually, it was, I would say it was I wouldn't call it ambiguous, actually, I would call it leaning towards ecocentrism, because the court was pretty clear that, see, this is not within our prerogative to define rights of animals, which is true. It's the job of the legislature. So let the legislature do its job, right? And of course, on fundamental right, it went on to say, it sort of cleared the air, cleared the ambiguity that existed, whether animals have fundamental rights or not, in terms of the Supreme Court decision earlier, because that is the binding law. It cleared the air that, see, we do not, that is our interpretation, and there was no fundamental right granted there. And as long as rights are considered, yes, rights, they do have rights, and that's what the parties have agreed, and that's what they've presented before us. But that is not judicial prerogative. That's the job of the legislature. Now, the question that I started with, right, is it truly transformative? And I think my understanding here would be that yes, there is an increasing movement, in fact, an accelerating movement towards transformative, eco-centric governance that the Indian judiciary is trying to further. In some cases, we do see some ambiguity, but most of these are leaning towards ecocentrism as opposed to anthropocentrism. Sure, there are one or two that are closer to anthropocentrism, but again, they do have ecocentric motivation there. So largely, I would say my analysis of the trend is that, yes, it's enabling, accelerating towards enabling transformative governance. It's not enabling yet, but it's accelerating towards that. It's moving towards that, and it's really leading the conversation there. However, of course, it needs legislative action, because at the end of the day, there's only so much interpretation that we can, courts can only, the job of recognizing rights and giving them content is at the end of the day a legislative mandate. The court is only there to interpret it. So of course we need legislative action. And as regards the judicial decisions go, I feel that there has to be a more clear engagement with environmental ethics literature, and of course more clear, so decisions that are a bit ambiguous, so more clearly sort of outlining what the rationale is for granting juristic personhood. And I think that would really clear the air and further this movement with more full steam on. Okay, so that's it from me. Thank you so much. Just put my email ID there in case you want to reach out, but I am happy to take questions now. Diana, should we stop the recording?